common question that we've been receiving is, how does this title deed conversion process affect apartment owners? Now, sectional units, which are multiple units of, say, apartments, townhouses, or offices that are owned by different individuals but lie within the same piece of land and have a single title deed, sometimes known as a mother title, are also subject to title deed conversion. Now, traditionally, these sort of sectional units have conferred ownership to the individual owners through subleases, which are then listed as encumbrances on the mother title. And the mother title is then transferred to a management company in which the individual owners have shareholding. Now, there are two major differences when it comes to the title deed conversion process, and they are that a sectional plan is a prerequisite for conversion of a sectional unit. And the second difference is the process of initiating the conversion process. So a sectional plan is basically just a georeference survey that identifies each of the units by the vertical axis and attaches coordinates to them. And you're able to basically tell where the boundaries of each apartment or each unit is. So this is a prerequisite prior to starting the process of conversion. Now, when it comes to initiation of the process, this depends on the three different scenarios. Basically, it depends on whether all the subleases within a particular development have already been registered, whether only some of them have been registered, so they've been registered partially, or whether it's a brand new development and no subleases have already been registered. So where the registration of subleases have been completed, the process of conversion can be initiated by either the developer, all of the unit owners together, or by one single unit owner. And once initiated, the government surveyor will proceed to prepare the sectional plan for all the units, of course at a cost, and then apportion the cost to each individual owner on a pro rata basis. After this has been done, the next stage would be the conversion process would proceed as usual, and the final output would be a certificate of lease for each individual owner. Now, where the process is initiated by one single owner, there's a bit of a difference. The one single owner will be asked to pay for their particular unit, and that's for the survey, for creating the sectional plan. And then for the other unit owners, a note will be made on the register that they're yet to pay, and they'll be required to make a payment prior to them doing any transaction on their particular unit subsequently. So that's the situation with a completely registered subleases for a development. The second situation, where they've been partially registered, only the developer can initiate the process, and this is to facilitate the registration of the remaining subleases. So what the developer has to do is give an undertaking that georeferencing shall be done. And then once all the subleases on the property have been registered, the conversion process can then proceed. And then finally, where it's a new development and no registration has taken place yet, again, it is the developer to initiate the process, and this has to be done right from the outset. So no registration can take place until the conversion has been completed. So that's it in terms of initiating and the differences between a single unit and sectional units. It's worth noting that for sectional units, they're also subject to a different type of conversion, which is conversion of subleases to title deeds under the Sectional Properties Act of 2020. But this will be the subject of a different video. The requirements are very different. What we've discussed today is the requirements for title deed conversion, which is migration from the old registers to the new registers. As usual, if you have any questions, please feel free to reach out by email or by phone, and we'll be happy to answer your questions. Thanks.